Hello viewers, welcome to this lesson on the High Courts in India, their composition, jurisdiction and functions. The Indian judiciary has a unified structure, although the constitution follows a federal structure with independent legislatures and executive. The judiciary is unified with the Supreme Court as the apex court and the High Courts for each state. An appeal lies from the High Court to the Supreme Court on a substantial question of law of general importance, and when in the opinion of the High Court, the said question needs to be decided by the Supreme Court. The Supreme Court appoints the judges of the High Court, but they are not under the supervisory jurisdiction of the Supreme Court. In terms of antiquity, certain High Courts such as the High Courts of Bombay, Calcutta and Madras were established before the Federal Court, that is the present Supreme Court, was created. They had the same jurisdictions and powers as the Supreme Court, and in some cases have original jurisdiction and wider powers. The High Courts play a very important role in the functioning of a federal constitution. The objectives of this lesson are to appreciate the origin and antiquity of the institution of the High Courts, to understand the role of the High Court in a federal constitution, to examine the scope of the powers of the High Courts, to understand the various powers of the High Court such as its appellate, original and review jurisdiction. The Indian judiciary has a unified structure, although the constitution follows a federal structure with independent legislatures and executive. The judiciary is unified with the Supreme Court as the apex court and a High Court for each state. The High Court exercises supervisory jurisdiction over all the courts in the state. The High Court is the apex court of the state. In terms of antiquity, certain High Courts such as the High Courts of Bombay, Calcutta and Madras were established before the Federal Court, that is the present Supreme Court, was created. Although they are under the supervisory jurisdiction of the Supreme Court, they have the same jurisdiction and powers as the Supreme Court, and in some cases have original jurisdiction and wider powers. The origin of the High Courts. Before the establishment of the High Courts in Calcutta, Bombay and Madras, there were two existing judicial systems for administering justice, that is the Supreme Court and the Sadar Diwani and Sadar Nizamat Adalat. The first High Court was established in 1862 in Bombay, Calcutta and Madras by the Indian High Courts Act 1861. These abolished the Supreme Court and the Sadar Adalat, which were established earlier by the Regulating Act 1773. Thus, a single body was conferred with all jurisdictions, that is civil, criminal, constitutional matters. The jurisdiction of these courts was defined by letters patent issued by the Crown. The Crown gave them power to exercise all civil, criminal, interstate, testamentary, admiralty and matrimonial jurisdiction. It also conferred on them original and appellate jurisdiction and all such powers and authority with respect to the administration of justice in the presidency as was thought fit. An appeal to Privy Council lay from the judgment of the High Court in civil cases when the amount involved was Rs 10,000 or more, or if the High Court certified that the case was a fit one for appeal. In a case of criminal origin from its original jurisdiction, or if the High Court certified that it was a fit one for appeal. The Government of India Act 1935 established the Federal Court, which heard appeals from the High Court. This removed the appeal to the Privy Council. Composition. Part 6 of the Indian Constitution deals with the states. Articles 214 to 231 of Chapter 5 of this part deal with the High Courts in the states. These provisions require that there be a High Court in every state of the country, and these courts are courts of record, which means that all the submissions and the decisions made are recorded and available in written form. The judges of the High Court are appointed by the President of India in consultation with the Chief Justice of India, the Governor of the state and the Chief Justice of that High Court. The judges hold office until the age of retirement, unlike some countries where the judges hold office for life. The judges are selected both from the bar, that is from lawyers who have at least 10 years standing, and from the lower judiciary, that is from district judges who have 10 years experience in that post. The judges of the High Court may be transferred from one High Court to another by the President after consultation with the Chief Justice of India. This power to transfer judges has been the site of a long battle involving questions of independence of the judiciary. In Union of India versus Sankal Chand, the government had admitted before the court that there was no justification for transferring a judge from one court to the other. This transfer of the judge was challenged as being without the consent of the judge, and there was no proper consultation with the Chief Justice of India. This case saw the beginning of the Supreme Court decisions on the independence of the judiciary, and the court held that the threat of transfer at the whims and fancies of the executive constitute a major threat to that independence. The transfer of a judge can only be made in public interest, and a transfer which is not in public interest can be challenged as unconstitutional. The term consultation that is used in the Constitution, although not meaning a concurrence, has to be a full consultation, not merely a formality. The subsequent decisions of S.P. Gupta versus Union of India in 1981, Supreme Court Advocates on Record Association versus Union of India 1993, In Re Special Reference number 1 of 1998, and the NJAC case, which is Supreme Court Advocates on Record versus Union of India, have strengthened the position with regard to the independence of the judiciary and also the appointment of judges. The Supreme Court, in the process of this litigation, has evolved the principle of judicial primacy in the appointment and transfer of judges. The collegium system of appointment of judges, which involves the Chief Justice of India and other senior judges who play a determinative role in the appointment of judges. Functions of the High Court. Article 225 of the Constitution of India states that the jurisdiction of the High Court shall be the same as it was before the Constitution came into force. This means that the jurisdiction of the courts under the old acts continued even after the Constitution came into force in 1950. Article 226 of the Indian Constitution confers upon the High Court a special jurisdiction to prevent the infringement of fundamental rights as well as other rights by the issuance of writs such as habeas corpus, mandamus, certiorari, quo warranto, prohibition and any other direction or order. This jurisdiction is notwithstanding any power that the Supreme Court has in enforcing fundamental rights under Part 3 of the Constitution. Thus, the High Court may enforce a variety of rights including fundamental rights. Its jurisdiction is thus wider than the jurisdiction of the Supreme Court under Article 32, where the Supreme Court only enforces fundamental rights. The High Court can issue a writ, direction or order to any government or authority if the cause of action in whole or in part arises within its jurisdiction. These writs are known as prerogative writs, as they originated in the King's power of superintendence over the due observance of law by his officers and tribunals. It is a discretionary power and must be distinguished from the appellate power that the High Court has been conferred by various statutes including civil and criminal statutes. Among these writs, the writ of habeas corpus is a very important writ which actually means to bring or produce the body. This can be filed when there is an allegation that the state has held a person without authority of law. This is an important measure to ensure that those authorities that are entrusted with the maintenance of law and order do not resort to arbitrary and illegal detentions. The writ of mandamus is issued against a government authority directing it or mandating it to do an act that it has a duty to perform but has not performed it. The writ of certiorari lies against an order of the lower court in cases where it refuses to exercise its jurisdiction or exceeds its jurisdiction. The writ jurisdiction of the high courts is very popular as it does not involve a lengthy procedure that is usually involved in civil and criminal cases. It is also very effective when dealing with cases against the state. The cases where the High Court has invoked its power of writ include matters of allotment of land, correcting the orders of the lower courts when they have wrongly exercised or failed to exercise their power, or have made an error that is apparent on the face of the record in cases of preventive detention and public interest litigation. The High Courts have been approached with regard to disputes regarding the imposition of President's rule in the states, corruption cases involving sitting chief ministers and other cases of significance. The High Courts have proved that they are not subordinate courts of the Supreme Court, but are on par with the Supreme Court with regard to exercising their judicial functions. The removal of the jurisdiction of the High Court by way of establishing tribunals has been struck down by the Supreme Court as violating the basic structure of the Constitution. In L. Chandrakumar v. Union of India, decided in 1997, the 7-judge bench of the Supreme Court held that the exclusion of the jurisdiction of the High Court was unconstitutional. All decisions of the administrative tribunals are subject to scrutiny by the High Court. Judicial review. One of the most important functions that is performed by the High Courts and the Supreme Court is the judicial review of executive and legislative action of the state. The historical reason for the establishment of these courts was to provide for remedies against arbitrary action of the representatives of the state. The famous trial of Warren Hastings, the Governor General of East India Company, saw serious allegations of violation of rights of Indians under the East India Company, and in order to provide some semblance of justice, the Supreme Court was established. Judicial review has been held to be a basic structure of the Indian Constitution in the basic structure case. The Keshananda Bharati versus State of Kerala case is known as the basic structure case. This case came to be filed as certain amendments were made to the Indian Constitution which the petitioners claimed violated their right to property. The court held that the right to property was not a part of the basic structure of the Constitution and the state had the right to abridge the right to property to further important social justice goals. The amendments also tried to take the matters beyond the purview of courts and exclude the review powers of the courts. The amendment stated that constitutional amendments were not law and hence the courts could not hear matters that constitutional amendments were not valid. The Supreme Court held that its power of review of all state action included the power to review constitutional amendments, as both the High Court and the Supreme Court had the power to interpret the Constitution. All actions of the state, including constitutional amendments, had to be in consonance with the basic structure of the Constitution. The power to examine if state action was in consonance with the Constitution is the power of judicial review, and this cannot be taken away even by amending the Constitution. Under this power of judicial review, the court can examine if any law passed by the legislature of the state is constitutional or not. All orders, directions, notifications, rules and regulations made by the state executive can also be subject to scrutiny and be held to be unconstitutional and arbitrary. The doctrine of arbitrariness that was evolved by the Supreme Court in the Maneka Gandhi versus Union of India case means that if any action of the state has been taken without following the principles of natural justice, that is the duty to act fairly, give reasons for decisions and to hear the parties before deciding a case, the action can be held to be unconstitutional. In the case of Maneka Gandhi, the passport authority impounded her passport without giving her an opportunity of being heard. The court held that this action violated her right to equality and liberty as it was taken without following the principles of natural justice. Interim relief. The High Court has the power to grant interim relief if the circumstances warrant an immediate order. These are also known as stay orders, which are interim orders until the matter has been disposed of finally. The court will grant stay only if it believes that not to do so would lead to irreversible damage and to address an injustice until the parties can be fully heard. Limitation rules. The power of the High Court to entertain any matter under its jurisdiction is not barred by any limitation. The general principle of laches and delay which apply to other civil proceedings do not apply to writ jurisdiction. If the delay is properly explained, the High Court will not refuse a remedy to the petitioner. Writ petition against private parties. The jurisdiction of the High Court is wide enough to take into account not only state actors but other parties who have been discharging important public functions. In the case of Zee Telefilms decided in 2005, also known as the BCCI case, the court held that the Supreme Court cannot issue any directions to the BCCI as it was not state, but the High Court can issue a suitable remedy. In reply to the argument that if there is any violation of a constitutional or statutory obligation or rights of the citizen, the relief may be obtained under 226, even though under Article 32 the Supreme Court may not be able to give any relief. The court relied on Andi Mukta Sadguru Shri Muktaji Vandaswamy Suvarna Jayanti Mahotsav Smarak Trust versus Rudani decided in 1989 to hold that Article 226 confers wide powers on the High Courts to issue writs in the nature of prerogative writs. This is a striking departure from English law. Under 226, writs can be issued to any person or authority. The term authority must receive a liberal meaning, unlike the term in Article 12, which is relevant only for the purpose of enforcing fundamental rights under Article 32. Letters Patent Appeal. The High Courts of Bombay, Calcutta and Madras have provisions for extraordinary civil jurisdiction under the letter patent appeal in certain matters. These are matters where the original civil jurisdiction of the High Court exists. In all other matters, the High Court is only an appellate court. Criminal jurisdiction. The earlier High Courts had original criminal jurisdiction, but the CRPC abolished the original criminal jurisdiction. The High Court is the appellate court in all criminal matters. Bail petitions may also be filed in the High Court after the trial court has refused bail. Appellate jurisdiction. The High Court hears appeals and revision petitions from the orders and judgments of all the subordinate courts in the state. These include civil matters such as land and contract matters, criminal matters and matrimonial matters. The writ proceedings under Article 226 are of a summary nature and are not suitable for raising disputed questions of fact which are best dealt with by the lower courts, and an appeal and review will lie to the High Court on whether the lower court has properly appreciated the evidence or has not properly appreciated the law applicable. The High Court in appellate proceedings has a wider jurisdiction and can reappreciate evidence and overturn judgments of the lower courts on both facts and law. Administrative functions. The Chief Justice of the High Court is in charge of the administrative work of the court, and he also distributes the work among his judges of the High Court. He is also consulted in the appointment of the judges of the High Court. Supervisory jurisdiction. The High Court exercises supervisory jurisdiction over all courts and tribunals throughout the territory in relation to which it has jurisdiction. The High Court can call for returns from such courts, make and issue general rules and regulations regarding the practice and proceedings of these courts. It may also settle tables of fees, also has the power to transfer cases from subordinate courts to it. The jurisdiction of the High Court may be extended to any union territory, or there can be a common court for two or more states. The appointment of the district judges shall be made by the governor in consultation with the High Court. The High Court exercises control over the posting and promotion as well as the grant of leave to persons belonging to the judicial service of a state. In conclusion, we have examined the role of the High Court, the function that it performs, and its position in the judicial hierarchy. We have observed that the High Court performs a judicial function on par with the Supreme Court, although an appeal will lie to the Supreme Court from the High Court. I hope you have enjoyed this lesson. We will meet again for the next lesson. Thank you.